Good morning again, Your Honors.
Good morning.
I am Heather Grew, and I represent the appellants Michaela and William Cross. In regards to time limitations, I would like to reserve 3 minutes for rebuttal.
3? All right, you may proceed.
This case is not about a good, loving parent with redeeming qualities. The child in this matter needs to be protected from appellee, just like all other children he could come in contact with. The trial court acknowledged there was not a relationship worth preserving between the biological father and the minor child through its best interest analysis and further restraining provisions regarding custody and allowing no contact between father or the child in any manner. The trial court found that appellants had proven by clear and convincing evidence that terminating appellee's parental rights would be in the child's best interest. The reason we are here today is because the trial court failed to apply the law properly regarding grounds to terminate appellee's parental rights and failed to terminate such. A short summary of the relevant facts are as follows. The minor child of this action was born in 2016 to two very young adult parents. Within the first 2 years of the child's life, the parties and the child moved more than 10 times across state lines from Texas to Tennessee and back again. This was due to father failing to maintain stable employment and provide necessary financial support. Mother did her best to maintain consistent employment despite the hardships of constantly moving. Quickly after the child was born, father began a pattern.
Let me make sure I got this correct. Mother is suing even though the trial court failed to find grounds to terminate.
Yes,
Is that correct?
mother and her husband, yes.
Okay. So what you're suing, what you're appealing is that the trial court determined that their termination would not be in the best interest.
No.
That finding
The
alone?
trial court, what we've appealed is the trial court failed to find grounds for termination. The trial court explicitly says in its ruling that if the higher court overturned that, then he was going ahead and doing a best interest analysis, which says the child would be served best by the termination. It would be in the child's best interest.
And you're asking us to determine that there are no grounds for termination.
Now, we are asking the court to determine there are grounds for termination and to terminate his parental rights. Yes, Your Honor.
Wait a minute. You're asking us to consider that there are grounds for termination?
Yes, Your Honor.
But how would that be in your best interest?
The appellants filed a petition to terminate and adopt in the trial court, asking that the trial court terminate father's appellee's parental rights based on his failure to support and his failure to visit. The trial court did not find that those grounds were proven, but went ahead and did a best interest analysis. So we are asking for the court to find that the trial court erred in not finding those grounds and to overturn or reverse, find the grounds, and terminate father's parental rights.
Essentially, as I understand it, the trial court determined that father had raised the issue of lack of willfulness, and the trial court determined that that defense was proven. Is that correct?
On which ground, Your Honor?
As to both.
He did, the trial court did find that failure to visit was, he did have a lack of willfulness due to mother's alleged thwarted efforts to thwart visitation with the child.
Did the trial court find that mother had thwarted those efforts?
Yes. It is our position that she did not.
The trial court specifically found that.
The trial court did say that she had thwarted the efforts of father to establish visitation. The father had not made the effort to establish visitation. The trial court found that the reasoning for this was mother had blocked father on Facebook, social media. But father had sent mother 31 or 30 letters from prison. That was still her current address. The trial court solely gleaned in on the visitation issue of she thwarted him by not allowing Kim access to her social media account, but he was not allowed
Let's
such.
go back to the social media for a moment. And let's take this one step at a time.
Yes, sir.
As I understand it, the trial court did determine that mother had blocked father on Facebook, or mother was no longer on Facebook. Is that accurate?
Yes.
Okay. And because of that, is that the thwarting that the trial court found?
Yes.
Is that the only evidence of thwarting?
To my
Or
knowledge, yes.
that showed a lack of willfulness on the part of father?
Yes.
Okay. What other means of communication did father have?
He could mail mother a letter, which he did multiple times from prison. Mother's address did not change.
Okay, she had the same address
Yes,
the
Your
whole
Honor.
time. Was there any phone contact?
No, mother did not have father, it's my understanding at some point, the timeline is not totally clear in the record. I did not do the trial in this matter. When she blocked him from her phone, but I don't know if he has continued to be blocked or when that happened.
Now, are we talking about blocking on Facebook or blocking on phone?
Blocking, I know that there was blocking on Facebook, but I believe then she blocked his access to text her phone number. But he was still sending letters, or he could have sent letters. She did not respond to the letters from prison, but as the trial court noted, they were addressed to the 3-year-old child and they were very inappropriate.
And when was the last letter received in relation to the filing of the petition?
I believe that father was released from prison sometime in 2023 and was on parole in Texas at that time. He had not sent a letter after leaving prison. So the determinative period, I think, was October of 2023 to February of 2024, and he did not send any letters during that time.
And correct me if I'm wrong, but did the father's mother have visitation with this child or some relative?
I believe that before he went to prison, they had lived at least one of the times with father's mother. So when he disappeared on the run from these sex crime charges, she was still living with his mother. The mother of this child was still living with his father's mother. But I do not believe that he made any contact through third parties during the determinative period to make any visitation. I don't believe there was visitation with the paternal grandmother either, not to my recollection.
Was there any visitation with any of father's family during this period of time?
No, and he admitted that he did not request such through any third party or family member.
Seems to me I read somewhere that there was some, but I may have misread that or misremembered it. Go ahead.
I will, if I am incorrect, I will let the court know in checking the record. I don't have all of that in front of me right now. So, father's failure to visit. He didn't make any efforts. He didn't contact a court. He admitted this. He did not file anything. He claims he saved money for an attorney to hire one to get visitation. But the court specifically found he was not credible in that claim because father further admitted he had not saved any money, despite having $1,500 a month in discretionary income. Father could have requested during the determinative period visitation in a letter, but he did not. He did not request it through third parties. He did not request it in any manner. So to my knowledge, there is no applicable law here that establishes a custodial parent is required to maintain social media access to the non-custodial parent as the sole avenue of communication, especially when the non-custodial parent cannot even legally access social media accounts due to his criminal convictions, which he did admit under oath he had done over 100 times and violated his parole. He had at least 6 or 14 social media accounts or something. So He did not redirect any of his efforts to visitation for the court, proving his willfulness and his intent. He had the ability to do so financially and still just did not do it. The trial court found that his failure was not willful due to her mother's refusal to cooperate with his efforts to coordinate visitation, which he did not do during the determinative period, restrictions upon his activities resulting from his parole conditions, and father's inability to afford to file a court action for visitation. We ask, it's our stance that if this court chooses to uphold the trial court's ruling on this issue, it could set the precedence that a custodial parent must be prepared to allow even a legal contact from the non-custodial parent to avoid allegations of thwarting attempts, and even when those attempts were in violation of established out-of-state court orders. In this matter, no party other than father prevented himself from visiting his child. The reality is, he never intended to visit during the determinative period. He did visit Tennessee during his parole. He got permission from his parole officer, but he never came to mom's address.
Was there any proof in the record that the father, during the determinative period, attempted any contact other than through social media?
Not to my knowledge, Your Honor.
Thank you.
The evidence proves that father willfully failed to visit, and therefore we request this court find that a ground and terminate his parental rights. I have 40 seconds, so I will be quick on the failure to support. There is a court order that reserved child support in 2017. It is our position that that court order was obtained by father's manipulation tactics. The trial court said that that court order absolved. It means that father did not have to pay during this time frame. Therefore,
Was the mother part of that hearing?
yes, she had asked the state to set child support, yes.
And did she ever return back to ask for child support?
No, she did not.
Okay. Was there ever any proof in the record that father asked for visitation with the child?
He did through a blocked Facebook message prior to the determinative period, but mother never saw that.
And at what point in time did father, or if it's in the record, did father realize that the Facebook messages were being blocked or that she wasn't receiving them?
To my recollection, he admitted in depositions that he knew pretty early on from those Facebook messages that she was not receiving them because it didn't have a little blue check mark or something.
So he knew when they were being sent?
Yes, that's my understanding.
Okay, thank you.
Good morning, Your Honors.
Morning.
I'm Angela Mueller. I represent Michael Henley, the appellee, who is the father of the child subject.
I believe you're going to need to step up a little bit, pull that microphone a little closer to you. Thank you.
Is that good? Better?
It is.
The petition only alleged one ground for termination. I was the attorney for Mr. Henley for the termination that was filed against him on February the 9th, 2024 in the Chancery Court of Gibson County. As I said, the petition only alleged one ground for termination, and that was abandonment. The petitioner stipulated at the outset of the hearing that they were proceeding with their petition based upon only one ground, and that was TCA 36-1113G1. Petitioners disclaimed any other grounds for termination that may have been an issue prior to the hearing. So here we go. We have the hearing. Father, before the hearing actually, I filed an answer for the father, and pursuant to Rule 8.03 of Tennessee Rules of Civil Procedure, we use the affirmative defense of lack of willfulness to both visitation and support, which is allowed under 36-1-102-1I. So after a lengthy hearing, the court gave its ruling by order on February the 20th, 2025. And that order ultimately denied the petition to terminate father's parental rights. So the question is, why did the Chancery Court not terminate parental rights? I'm glad the Chancery Court didn't, because I think that my client and I proved by preponderance of the evidence, and the court agreed with us, that there was a lack of willfulness in visitation and in support. So I want to start out with the Chancery Court's findings of fact, conclusions of law from its February 20th order, specifically paragraph 7 that reads, "The respondent has established the affirmative defense of lack of willfulness, and such failure to visit was based upon mother's refusal to cooperate with his efforts to contact her to coordinate visitation with the child after his release from prison." And there were several other factors, but I want to specifically hone in on this factor, because if you look at the record, that's where most of the evidence is. You will see a history of the mother's refusing attempts by the father to see his child and to support his child. And so what the Chancery Court did in its order, it cited in Re Bentley E, where those, in that case, courts consider events that occurred prior to the relevant period of determination if there was interference with the biological parent's attempt to visit or support the child.
So let me ask you this, Ms. Mueller, what facts in the record do you rely on to show that the father attempted to visit
Yes.
but was denied
Yes.
after he got out of prison?
Yes, I'm going to get to that. That was my next sentence. First, we're going to consider the 4-month period before the termination was filed. So from October 8th, 2023 to February 8th, 2024, we have in the record, we have on Mother's Cross, that's volume 2, page 38 through 39, and also in volume 3, there are Facebook message posts. One was September 13, 2023, September 22, 2023, November 21, 2023, December 5th, 2023, and February 16th, 2024, March 8th, 2024.
Is there any evidence in the record that the mother got any of those messages?
Well, this is what Mother testified to, because I don't know. Here, this is what she testified to. He sent her this Facebook messengers on those dates. He sent her a post about having insurance for the child, and he wanted to talk to her about that. So he sent her all these posts. Mother, in the record, testifies that she never responded to the post because she said she didn't receive the Facebook post because she had blocked him before he went to prison. And then she says, well, when he got out of prison, I unblocked him. But she said in the testimony in court and in the depositions that she doesn't know why she didn't get the post, but she says she didn't get them. So either she lied and she got them and she just wanted to ignore them, or she didn't get them, but she didn't get them because she blocked him. So either way.
So what did the court, as the finder of fact, determine was the fact?
He determined, the court determined that, and I'll quote from the paragraph that the court determined in its order that these Facebook posts, or that her blocking him was an interference with his ability to visit.
So did the court make a finding as to whether the mother actually got these posts or these messages?
No.
Or whether she was prohibited from getting them because she was truly blocked during that time?
He never made a finding on that. It was kind of a mystery.
So the court didn't find that she blocked him on Facebook?
He did find that, specifically, that she says that she blocked him on Facebook. So he believed that testimony. He believed her testimony about her blocking him on Facebook.
Is Facebook the only way to get in contact with somebody?
Well, that, if I can consider, if I can get the court to consider the period outside of that, we'll see a history of how they communicated. So, mother testimony, she went on to explain that she had blocked the father from her Facebook, and I've already explained that. But we'll also see that mother had stopped all contact with the father in April of, or actually May of 2019. They used to text through phone, they used to Facebook message each other, but she decided, and this is in the record too, in volume 3, that the mother had a talk with her grandmother or some family member in May of 2019, or April 2019. And they agreed, based upon this conversation that's in the record too, that she was going to block all contact with the father because of these criminal, at that time, allegations that were pending. So the mother decided that she wasn't going to talk to Dad anymore. So they had previously had a play date set up in the Dyersburg Park with the child and the father. But she decided unilaterally not to show up for that play date. So my client, the father, shows up, but there's no mother and there's no child. And the mother never let the father know that she wasn't going to show up. And she had blocked him at that point, so he could not have any communication with her. Because the way they communicated was Facebook or through phone. And
What
that
about
was
letter?
not letter.
He'd written letters.
He had written letters when he was in prison. I believe those are in the record as well. And his testimony is, which is also in the record, is that when he got out, he knew he wasn't welcome just to come knock on her door because he knew she had been remarried. And he knew, basically, since she didn't answer any of the letters that he had sent, or he didn't even know why would he even attempt to send any more letters because she never answered any of the other ones.
Well, why would he attempt to send any Facebook? Because she never answered any of those.
Right, that's true, but he did.
He did?
He did.
So why didn't he send another letter?
I don't know, that was never discussed in the testimony, Judge.
And even in situations, both of you practice law long enough to know that there are a lot of parents who have children who don't like each other. And they don't necessarily have to like each other.
Yes.
But they can resort to the court system to obtain any visitation they want to.
And Your Honor, that's exactly what the father was doing. And that's in the record as well. There's a receipt. In February 2024, he had a consultation with an attorney in Dyersburg, specifically to talk about getting an order for visitation.
But he never pursued anything, did he?
He did, well, he subsequently, like a week later, he was saving money to hire this attorney because the retainer was very expensive. But he subsequently, the week later, got served with this termination petition.
Didn't the trial court make a finding that the father's testimony was not credible on saving up money?
No. The
They did
trial
not.
court did not find that. As a matter of fact, if you look in the court's order, the court says that testimony in regards to willfulness was credible. He never said anything about testimony in regards to money, whether it was credible or not credible. But he did say in paragraph 9 this: when petitioner mother failed to respond to respondent's attempted communications, respondent decided to attempt to save money and hire a lawyer to get visitation with the child. He met with a lawyer in Dyersburg, Tennessee in an effort to start that process to get visitation, but could not afford to proceed at that time. He later learned that the instant petition had been filed against him and actively responded to and defended the same, ultimately through court-appointed counsel. The court found that respondent's testimony in that regard was credible. That is in his order. That's in the court's order. So he found that the visits were thwarted by mother's actions. And he found that, therefore, that affirmative defense was proved by preponderance of the evidence, and so that ground of abandonment failed. And then we have the ground on the child support. And I would just like the court to know that not only was there evidence in the record that the court, or that the father was rebuffed by mother when it came to visitation, but he was also rebuffed when he tried to support the child. And that is, I would say, if you look at volume 3, it's interesting to see that when the father tried to put money into an account, and this is in her testimony, that in father's testimony as well, he tried to put money into an account. This is like 2018, 2019. The mother closed the account to prevent father from doing so, and she messaged him, and these messages, they're all in the record, quote, "I told you I would close it because I don't need your bribe money." So to which father responded, "It wasn't bribe money. It was me keeping the promise of sending you the money by check." Then we also get into volume 3. There's another Facebook Messenger post that the court can look at that says the father asked mother for the child's social security number so he could put her on his insurance, which was the agreement that was in Dyer County Chancery Court. Mother's response was, and I quote, "Hell no, I will not give you her social." So again, the court looked at the fact that it's permissible to go back before that 4-month determinative period and look at the history of these parents to see that there was interference.
But the father did get her on this insurance,
He did.
correct?
He did, and that was what he was trying to tell her in the Facebook post messages in 2023 that I'd referenced earlier, those several Facebook messages, and he had sent her a copy of the card, a picture of the copy of the front and the back of the card. That is in the record as well, Your Honor.
Also during the time when she had him blocked.
Yes. So she never knew, according to her testimony, that he had gotten her on the insurance when he got out of prison because she had blocked him. And so my client had enough, I guess it was common sense. It's like, well, I don't go and knock on a door of someone that I know hates me and is remarried. And she didn't respond to my letters, and she didn't respond to Facebook, so I don't know how, and I don't know how to get in touch with her. And that's why he went to the Dyersburg attorney to get the ball rolling, to go back to Dyer County Chancery Court, where that order of support was from, to get visitation set. And before he could do that, he served with his termination petition. And that's where we are. And I only have 5 seconds, so I can't get to everything else I wanted to talk about. But thank you very much.
Thank you.
I would like to first address the credibility issue that just came up. It is the best of my recollection that the court did find father not to be credible on this singular issue of that he was not telling the truth about saving up money for attorney's fees. Unfortunately, I do not have my computer in front of me, therefore I can't quickly just look for the word credible throughout the record. If I have made a mistake, I will supplement the court and let them know. Regarding the financial support that father could have made, the trial court found that, like I said, he was absolutely, that order said reserved on child support. Therefore, he didn't have to pay any, but that's not what the applicable statutes tell us. This court has found many times that when a parent's over the age of 18 and they know of a child needing financial support, they need to do that regardless if there's an order or not.
Are you saying that even though there was a court order in those other instances that a court order would not be dispositive of that issue?
Considering it did not waive child support or did not, deviate it down to zero, it reserved it. And father admitted that how they got to that.
Either part, your client could have taken him back to court and asked that the issue be resolved.
Well, he did follow their agreement, which led to that order, and
Not as far as child support's concerned.
Well, he deposited 2 child support payments, financial assistance payments in her bank account, and then went on the run from the law.
It seems a little difficult for me to say the father didn't do what he was supposed to do if he had a court order saying the court's holding this matter in abeyance pending some further action, and no further action was taken.
Considering the facts and circumstances of this case, he went on the run after making the second payment. Then he went to prison, he pled guilty. Then he got out of prison, was on parole. Mother did have a conversation, as appellees at council stated, and decided to block him because of the allegations, which then he pled guilty to, of sex crimes against a child. She had a small female child. He was a family member that he had for protection. The court found that she did block him for her protection. So he gets out of prison, and he did maintain health insurance through an employer, I think 2 months out of the determinative period, because he couldn't keep a stable job. Is it her job, thinking he's gone prior to the determinative period? Like, he's in parole, maybe she knows he's on parole, maybe she thinks he's still in prison. Maybe it's because the time stopped. I appreciate your consideration today.
Thank you. Thank you, counsel. We will take this matter under advisement and attempt to get you an opinion at the earliest possible time. We will stand in recess to the call of the docket this afternoon.
All right.